The other two categories of bills, which are outlined in the South African Constitution, are Section 74 bills and Section 76 bills. Section 74 bills, which are amendments to the Constitution, have special requirements and procedures in order to be processed. First, only the executive, a portfolio committee, or an individual member of Parliament can introduce Section 74 bills. Second, the size of the majority in the National Assembly that is required to pass a Section 74 bill, and whether or not the National Council of Provinces must also pass the bill, depends on which section of the Constitution the bill is seeking to amend. For example, amending the founding provisions of the Constitution requires a 3/4 majority, or 300 members voting in favour. Changes to the Bill of Rights need a 2/3 majority, or 267 members voting in favour of the amendments. Lastly, all other constitutional amendments that affect the country's provinces must be passed by both the National Assembly and the National Council of Provinces. In these cases, a 2/3 majority in both houses is required for the amendments to be passed. Other constitutional amendments do not need to be passed by the National Council of Provinces, but all amendments must be submitted to it for public debate, regardless of whether they require its approval. All constitutional amendments must be published in the Government Gazette, with a call for public comment at least 30 days before being introduced in Parliament. After the bill proposing amendments to the Constitution is tabled, 30 days must pass before it can be put to a vote in the National Assembly. Section 76 bills are ordinary bills that affect the provinces. They can be introduced in either the National Assembly or the National Council of Provinces, and they must be considered by both houses. When a Section 76 bill is introduced, it is first reviewed by the relevant committee in that house. The committee may hold public hearings to gather comments and suggestions. After this process, the bill is tabled and debated in the house in which it was introduced. If the bill is passed in the first house, it is then tabled in the second house. The relevant committee in the second house also reviews the bill and may hold public hearings for additional comments and suggestions. All Section 76 bills are required to be taken from province to province by members of the National Council of Provinces for public participation there. Only then can the bill be debated in the second house, and if it is passed, it is sent to the President for consideration and signing into law. However, a Section 76 bill takes a different route if the second house rejects it or decides to pass it with amendments. In such instances, the bill must return to the first house where it was initially introduced. If the first house does not agree with the second house's rejection or proposed changes to the bills, it goes to a mediation committee that tries to reconcile the differences between the two houses. The mediation committee consists of 18 members, 9 members of Parliament from across the political spectrum, and 9 delegates from the National Council of Provinces, 1 from each of the 9 delegations represented in the NCOP. A compromise is reached if at least 5 representatives from the National Assembly and at least 5 representatives from the National Council of Provinces can agree on the bill. If a compromise is reached, the bill is sent to the President for final consideration and signing into law. If no compromise is reached within 30 days on a Section 76 bill that was first introduced in the National Council of Provinces, that bill lapses. However, if no compromise is reached on a Section 76 bill that was first introduced in the National Assembly, Parliament can override the National Council of Provinces and pass the bill, but only with a 2/3 majority vote, or 267 votes. Whether it is a Section 74 bill or a Section 76 bill, if passed by both houses, it ultimately goes to the President for final consideration and sign-off. The processes for bills proposing constitutional amendments and ordinary bills affecting the provinces are designed to ensure extensive deliberation and representation. Higher thresholds are required for constitutional amendments, reflecting their profound impact on the country's legal foundations. Ordinary bills affecting the provinces must navigate a collaborative process to address the concerns of the 9 provinces. This approach enriches the lawmaking process, ensuring that the laws it produces resonate with the people that they are meant to serve.